Can interim maintenance be granted without considering a statutory defense? Can a matrimonial case be transferred solely for one party's convenience? And can the Enforcement Directorate's investigative action escape judicial scrutiny? Let's decode this week's most significant judgments. In Himanshu Chordia vs. State of Rajasthan and Another's 2026, the Supreme Court held that the court cannot grant interim maintenance without considering the husband's statutory defense under Section 125 subsection 4 CrPC. In this case, the husband alleged that his wife was living in adultery and produced prima facie evidence. But the trial court and the Rajasthan High Court granted interim maintenance without examining the plea. Setting aside both the orders, the Supreme Court ruled that such a defense must be considered before granting interim maintenance and remanded the matter to the trial court for fresh adjudication. The judgment reinforces that interim maintenance is not automatic and must be decided after considering all the statutory exceptions. In Srimati Anjana Rana vs. Navin Singh, the Allahabad High Court considered whether a matrimonial case should be transferred solely for the convenience of the wife. The petitioner sought transfer on the grounds of personal inconvenience and the welfare of the minor child. The key issue before the court was whether these factors alone justifies transferring matrimonial proceedings. Dismissing the transfer plea, the High Court held that the convenience of the wife and the welfare of the child are relevant considerations, but they cannot automatically justifies a transfer. The court emphasized that every transfer application must be decided on its own facts by balancing the convenience of both the parties and the overall interest of justice. In Karnataka High Court, Messrs. Gamescar Technology Private Limited and others versus the Directorate of Enforcement froze the bank accounts and investment of Gamescar Technology under the Prevention of Money Laundering Act 2002. Challenging the actions, the company approached the Karnataka High Court under Article 226 of the Constitution. The key issue was whether the company could challenge the Enforcement Case Information Report and the freezing order through a writ petition. Justice M. Nagaprasanna held that the action taken under the Prevention of Money Laundering Act are open to judicial review and rejected the ED's objection that the case was not maintainable. The court directed that the petition be held on its merit, reaffirming that even investigative power of the ED are subject to the constitutional scrutiny by the High Court. And that's all for this week. Stay tuned with Law Times for more such insightful judicial updates. Thank you.